Welcome. We are live. We are live. We decided to start the broadcast from the Facebook page. My name is Candy Johnson. I am your host, and this is Official Essentials, brought to you by Eagle Legacy Factory Private Foundation. Today we're gonna delve into um, some processes. The people who are familiar with UCC and secure party processes, um, you might want to tune in and stay tuned in. You also might want to subscribe, and we definitely suggest that you make comments. Let us know how we're doing as far as content. Um, you can ask questions to help us produce good content, um, clear and detailed information. I love questions because it helps me to identify what the hearer needs to hear, to get an understanding of the what I'm relaying, and it also lets me know um, where they are not um, receiving the communication that I'm trying to relay. For example, sometimes people just go on and on and on, and they're supposed to be teaching you something, but they appear to be rambling in a sense because you never got an opportunity to ask in between them disseminating the information or explaining a particular aspect of the information. You could have interjected, hey, wait a minute, I don't understand what this meant, and I don't understand what that meant. And so that is what the live broadcast is purposed to do, to allow you to ask those questions, to interject while we're trying to present the information. We want you to interject your um, objections or whatever, not necessarily objections, but um, yes, even objections. Some people say, okay, this it seems objectionable and or unlawful in some nature because they have been programmed, and so we want to address their concerns, but we will be moving right along, because this broadcast is not for children, it's for adults. And so we're going to take a little time to help grow you up. This is why we'll be discussing the difference between an adult, a minor, and a mature person. Okay? We'll be discussing what a person is. And so we can get an understanding of what a person is. And we don't disregard the little peoples, but we don't get instructions from the little peoples either. So if you have any negative comments, you can contribute those, and we appreciate your contributions. But we also gonna disregard them. Please note that in advance. Now, we don't disregard people's perspectives or views. We just disregard them as something we need to concern ourselves with. That's we accept it as your issue. That we not. And none of us have no interest in that and no objections to what we're trying to do. We need people who are agreeable. We're going to be learning what agreement means in this fellowship. And this is a fellowship of information database. Money. Money, money, money. Let's get it. All right. Um, we're going to go to, he had it on his page. Uh, and I just had it. These motherfuckers, people with this so-called health care, they be doing the most. Oh yeah, we gonna watch that too. Mm, that's Nelson. We talking about purpose today, eh? We talking about purpose.
Yeah, I'm gonna do live like about 30 minutes. 30 minute. Peace, family, peace. Make sure you share. Quick beans for the road, quick journey. All right, pop-up live. Yeah, we gotta talk about it. How many? Comment 8 if you're a person that believes in horoscopes. We're gonna jump right into it. Peace and love. Make sure y'all share. All right, question of the day. Comment 8 if you believe in horoscopes. All right, I am a person that believes in horoscopes as well. All right, just to make people comfortable. All right, comment 8 if you believe in horoscopes. Comment 8 if you believe in horoscopes. And then after you comment 8, go ahead and drop your horoscope sign. Go ahead and drop your sign. All right, I'm a Libra. Okay, I'm what you call a Libra. All right.
Welcome to another edition of Florida Appeals Journal. It's fall 2024. We finished with the summer. So now we get into some exciting issues facing litigators this year, the last part of it in 2024. Today, I want us to talk about...
I'm so sorry, y'all. We cannot see any of your comments right now. I appreciate you commenting, but we're going to be discussing about documents and affidavits and things of that nature in this broadcast. I was looking for a post that Chris made. I was just looking at it. I don't know what happened to it. It was just here. And so I scrolled up on another post and just tapped into that, but that wasn't what I was looking for. Mm, mm. Hold on 1 second, baby. All right. Crapola. I was looking for that video on his channel so that I can go to the video. Hang tight. We started this broadcast live session so that we can discuss some issues that we're having with the live broadcast system. Not so. Now, who told that to please?
Construed, and the district court's standard of review is known as. Good afternoon. Welcome again to another week of Florida Appeals Journal. I hope everyone is continuing to do well, as can be expected under the circumstances we all find ourselves in. So let's take advantage to and spend more time to learn new things that helps us in our practice and in the litigation world, at both the trial and the appellate courts. Today, I want to talk about extraordinary writs, and specifically the writ of a certiorari, petition for writ of certiorari. What does that mean? And the writ of certiorari is one of several extraordinary writs, which means you don't technically call it an appeal, but it is a proceeding. It's an extraordinary writ proceeding that you bring to the appellate court under very limited circumstances, and we're going to discuss that today. So you'll know the answer to the question on what is the petition for writ of certiorari all about. When can I use it? What's the standard of review for a petition for writ of certiorari?
Before we get into all of that, we got to understand what even a standard of review is. We got a new subscriber. Thank you for subscribing. And a standard of review is sort of like the measurement that they use in court to decide whether you have a case, what type of case it is. And you got different rules depending on what type of case it is, and that's booked as we have the federal level, which is the standard of the way that they review a case. Is going to be constitutionally based. Okay, it's going to be common law based. It's going to be natural law based. It's supposed to be. But so if you are seeking to be sovereign, you must understand at least these three basic laws that are in effect in every judiciary, in all judiciaries. If you're going to govern yourself, you need to understand these three laws: natural law, common law, and you also need to understand the federal laws, because that's when you are operating in commerce, those laws are in effect whether you want to be governed by those laws or not. You cannot extradite yourself from jurisdiction um, of federal laws because federal laws uh, have everything to do with anything commercial, anything in the public. And so, since you are engaging in the public, how can you then say that you don't fall under that jurisdiction? Even people who live in the woods, so to speak, living off the land, all right? You're living off the land, you're here. Um, so, if you go on your land and you start um, conjuring up um, toxins on your land, now that affects the rest of us and global pollution. And so that's a global community issue. And that's how, or I should say, that's what realm of your jurisdiction you fell in when you did that. Now, if you live on your land peaceably and don't cause any potential harm to anybody else, then we'll never know you even there. But if you doing something that alerts somebody that you there that is unnatural, then you fall under the jurisdiction as well of natural law. Meaning the citizens, the people around you can say, hey, oh, hell no, you can't do that. Or you got it stinking on my side because you got something brewing over there uh, not right. And so this is what we mean by jurisdictional grounds. And people need to understand what a ground is. It's not, don't have anything to do with the literal ground. It's the grounds with which you standing on. Uh, how shaky is that? Or how substantial is it? How much you, what do you got to back it up? You understand? You got to back that shit up. You can't just be um, you know, going by what other people say, because then you if you go by what other people say, you on shaky grounds. That's why a lot of times when people go in court and they have that piece of paper trying to recite what somebody else told them to say in court, they'll tell you you can't do that. You cannot do that because you're not representing yourself. The whole purpose of going into court was for you to represent yourself. And what you're saying to the court is I'm mature enough to, and I have enough knowledge to represent myself. This is why they seem to force a lawyer on you, but they not forcing anything on you. You brought that on yourself when you wasn't representing yourself right. And you allowed jurisdiction when you acting like a minor. Trying to read off a sheet of paper you should have memorized and got a full understanding what was on that piece of paper before you went to court. I have, I know one guy. He's really good. His name is Youssef. He's at the with that SPC University, and he is very knowledgeable of the court's practice and legalese and all that. And so um, he also um, have developed his own style. So when he rap off that law, he rap it off, baby. It be on point. It be intelligible, and he sounds sovereign. He sounds sovereign because if you speaking in that manner where another you're relaying to another person that you know what you're talking about, it may even make them unsure of themselves, especially when they don't have much grounds that they standing on. It'll make them start getting in them books. I seen one of them solvers that made that judge get in the books, baby. He said that y'all be laughing at these solvers, but baby, these solvers making these lawyers and judges get back in the books. You dig? They making them get back in the book. And because a lot of them just been practicing. They just been practicing. They ain't really uh, have no degree of knowledge in law. Because a lot of them, I don't even see them making no kind of constitutional arguments worthwhile. They be weak and incompetent. They be weak and extremely incompetent. And I've seen a corporation have a lawyer represent him affecting natural law rules on his client behalf more effectively than a person actually representing the natural client. And so, if you don't understand what I mean by natural and not natural, I don't know what to tell you. Yes, I do. Natural and not natural is when you have a party in court and it's just a person on one side that's in court, and then you have a corporation on the other side against the person, like a bank against you for your foreclosure and stuff like that. Um, you didn't know that some of the banks are having some representatives to come in there and present themselves as a person so that the court consider y'all equal. But your lawyer, if you get one, he's supposed to make sure that that court uh, take judicial notice. I learned that from USEP as well. Make sure that court take judicial notice that we are not equivalent. And you are a consumer, and if you take in the position of the consumer, you can do that and win. And when you are taking the position of the original creditor, you don't have to be the consumer. You can be either or. Both positions belong to you. And people always say they cheating on us, but they not, because you're not realizing that we they doing a lot of cheating because we already got the upper hanging. If you got two sides and they got one, how many hands they got? They can only be the drawer. They can only be a temporary power of attorney. They can only be a trustee, an indentured trustee. They can only be uh, a licensed representative for the estate. They can never access the estate directly. You can access the estate as the uh, trustee, and and as well give instructions to the trustee, trustor, to the recommendations, however you want to put it, the point is you got two positions that you can operate from, and they only have one. Then we need to be very clear on that, because it's a lot of people mixing processes, because you could you going in, sending paperwork as you trying to get out of the system, so called, uh, but yet you want to process a presentment which is in the system. Them two different things, sweetie. And so that's not intelligible. It's no process that tell you need to do that. All you need to do in your sovereignty is be sovereign. Make a decision. Make a pimp decision. Do you have to be a creditor at all times? No, you do not. Do you have to be a consumer in the transaction? No, you do not. You can be the lender instead of the borrower. And they're trying to make you believe that you is the borrower. And that's why you believe you have to pay that bill, because you think you is the borrower. And that's a whole pill to swallow. That's a whole pill to swallow right there. Even people that want to run out into the woods and stuff and live off the land and everything, bless their heart, they just been overwhelmed by society and everything. But then they want to dip their ass back online, all on YouTube, with their nature videos. You still online. You still... But they want to stay, they claim of independence in some manner, and that's what they do. You still tapping into our infrastructure. You don't want to be a part of, you say. Bless your heart. That's funny. That's like saying you don't want to play with us, but you want to use our ball. Ooh, dropping jewels. Where my gift pack at? Let me go to my gift pack. Boom. Up. 73 subscribers. We just got a new subscriber, y'all. Hey. We just got a new subscriber. Hey. Back to the video. All right. So what we're going to do here is we was going to watch a video about yeah, there we go. Where do we put him right here? Okay. All right. Ready? Y'all ready? Okay.
I started working at the barbershop and...
Okay, bro. Do the best you can. That's all I can say for you. Just do the best you can. Chop them up right now. Don't be plugging nobody while you interfering with my broadcast. Don't plug nobody.
I don't have any insurance. This is not good. Through healthcare.gov. Hello. In this video, we'll be going over IRS Form 1099-A, acquisition or abandonment of secured property. So lenders will file this form for each borrower if they lend money in connection with their trade or business.
Notice he said lenders. You can be a lender or you can be a borrower. Just keep it moving.
And they acquire an interest in that property that secures the debt. And or if the lender has reason to believe that the property has been abandoned. For example, a primary residence that's secured by or a mortgage that's secured by a primary residence, perhaps a car that's been repossessed, things of that nature where the lender actually acquires the underlying security that is the collateral for the loan. However, lenders may not always file Form 1099-A if they cancel a debt that is $600 or greater in connection with a foreclosure or an abandonment of property. Instead, they may file IRS Form 1099-C since they're already required to do so. That's the debt cancellation tax form. And they can report the basic information that's required on Form 1099-A, which is the outstanding loan balance and the fair market value of the property. That can be reported on 1099-C. The primary tax implication to the taxpayer or the borrower is depends on whether or not the fair market value of the property that they gave up or abandoned is greater than or less than the balance of the principal that was outstanding. So if the fair market value of the property that is listed on Form 1099-A is less than the outstanding balance, and that balance goes away, there may be tax implications and they may need to report that on their tax return. So we'll cover that a little bit more detail later in this video. We do cover it extensively in our article, so we'll put links to our article in the show notes. Let's go ahead and walk through the tax form itself. So on the left-hand side, we'll see the tax information for the lender and for the borrower. So in this case, our hero, John Doe, his lender is Acme Lending Solutions, and they are filing this Form 1099-A, and they're giving this borrower's copy to John Doe. This is copy B, so copy A of any 1099 always goes to the Internal Revenue Service. Copy B, in this case, goes to the borrower, and then there's a copy C, which Acme Lending Solutions will retain for their records. So in copies B and C, you'll see that the borrower's taxpayer ID number is truncated, meaning that they're only going to show the last 4 digits of either the Social Security number, the individual taxpayer ID number, it could be an adoption taxpayer identification number, or it could be an employer ID number. So the copy A that goes to the IRS will always contain the full tax ID number. So we've got John Doe's contact information, his street address, Oh, Acme Lending Solutions would normally enter their phone number, so let's put in their.
This might look like just an ordinary hiking stick to you, but you're not going to believe what this thing has inside. Let's go ahead and start with the bottom of this thing. If you untwist it, boom, there's a flintstone to start a fire. And then you go ahead and twist off the next section, and what's stored in there? Fishing line, a hook, and a weight. And then
Get in there, get their phone number in there. And if they add an account, such as some sort of a banking account number, you might see that under the account number field, but it doesn't, there's no practical purpose, there's no tax impact if they don't have that. So on the right-hand side of the form, we have 6 basic fields. They're fairly straightforward. So
I want to point this out right quick. He said it was no tax implications for that being filled out or not, because that is information you put for your own personal what I mean by personal, because a business is a person. And so if you are processing paperwork for your business, then you would provide your business banking information. I believe is what he's saying. It's optional, and it has nothing to do with the filing of the taxes or computing of anything. It's just your banking information when they, if you want to have whatever returns or refunds that you may have from processing these documents, that you may choose to have that routed to your bank. And so your banking or your business banking information would be included in the case where you are doing business in commerce. And so if you use these documents, please understand you're not getting out of anything, any systems or anything like that. We are utilizing the bill of exchange and operating in commerce according to the rules. This is why we're taking the time to learn the rules so we can abide by the rules when we are processing these documents. So we don't get a tap on the hand when we can say that we honestly did take time to process their paperwork in honor. Moving right along.
this was for calendar year 2023. On this form, the lender, Acme Lending, is reporting that they acquired this property or they knew that it was abandoned. It could be either or on June 1st, 2023. So if in the case of an acquisition, this would be when they actually foreclosed on the property, when they actually had the deed or the rights and burdens of ownership of that property. So the interest in the property is usually acquired on the earlier of either the date that the title is actually transferred or the date that the lender has to start taking over the burdens and benefits of owning that property, paying property taxes and things of that nature. For in the case of an abandonment, that's a little bit different. Like in the Great Recession, when thousands of homeowners just walked away from homes, banks had a hard time of knowing exactly when that abandonment took place. So this would be reported as the date that the bank or the financial institution knew or had reason to know that the property was abandoned under normal circumstances, unless they were already going through a foreclosure proceeding or something of a similar nature. In box 2, it's going to be the balance of the principal outstanding. It's going to be less than the loan amount, and it's not going to include any interest that was accrued. So it's only going to include any unpaid principal on the original loan balance. And this will be as of the date indicated in box 1.
Okay, so you're just in a car accident, your neck is throbbing, your back screams every single time you move, you can't sleep, you can't feel.
In box 1. Box 3 is reserved for future use, so there should be nothing in that field. Box 4 is going to indicate the fair market value of the property. If it was sold at a foreclosure or an execution or some similar proceeding, then it would generally be the sales price. Otherwise, it might be the appraised value. If this box 5 is checked, then the form instructions indicate that this fair market value of the property should be the same as the appraised value of the property. So in the case of a primary residence, this would be based probably on whatever if the bank or financial institution obtains an appraisal. So depending on their internal rules, it might be the appraisal used to justify the loan. If a certain amount of time has passed, they may request another appraisal to update that fair market value. And the reason why it's important for a taxpayer to know this is because the difference between the loan balance and the fair market value of the abandoned property can play a role in determining whether or not you need to claim or recognize a capital gain for tax purposes. So yes, it is theoretically possible for a taxpayer to abandon property and still walk out on the loan and still have to pay taxes on the forgiven amount.
You heard that? He said, and still have to pay taxes on the forgiven amount. And that's because you didn't know that it had been forgiven. And who it was forgiven for. When these corporations file these documents, they forgive themselves for you. Meanwhile, you still thinking that you owe them. And that's the coldest one right there.
And then in box 6, this is going to contain the description of the property. So the form instructions have detailed guidance on how to enter real property, personal property such as a vehicle, or things like office equipment. So in this case, it would be the address of the property. So we'll say that it wasn't his primary residence, but it was a rental property that he had down the street. So you might see other supplementary information. It may be, single-family residence, things of that nature.
Right.
So there's not a whole lot of specific guidance in the form instructions for what borrowers should do, but there are resources on the IRS website to help people determine whether or not they need to report abandonment of property for capital gain purposes. So we do outline this based on different criteria. For example, there's a different treatment of fair market value based on whether or not this was recourse debt or non-recourse debt, and whether or not the property was used for business purposes or not for business purposes. And then there's also an exclusion, a tax exclusion available through to 2026 for qualified principal residence abandonments or debt cancellation. So